Well, good afternoon, everybody. Welcome to this FTB planning webinar. My name is Andrew Fraser-Urquhart QC. With me today is Esther Drabkin-Reiter, and we're going to be talking today about the tilted balance in the 2019 version of the NPPF. The tilted balance, of course, being one of the fundamental parts of the NPPF. It was a fundamental part through paragraph 14 of the old NPPF, and that importance continues on into the current NPPF. Now we're going to both be giving you some thoughts on the tilted balance today. I should perhaps first of all introduce Esther to you. Esther Drabkin-Reiter was called to the bar in 2017. She's already established herself as one of our most talented juniors. I know that to my own cost because she bested me in a case we did together in one of the outer London boroughs, a very messy enforcement case, and she was on the winning team, and we don't talk about what happened to my case. But she's a very, very able and fast rising junior, and she's going to start by taking us through some of the central provisions which set out the text and the importance of the tilted balance in the NPPF 2019. Esther, good afternoon.
Good afternoon, everyone. Thank you, Andrew. So just a quick run through the topics we're going to cover in this hour. And I should just mention that we would welcome questions from you on any of the matters that we deal with this afternoon. Do include them in the Q&A box at the bottom of your screens. We'll see how much time we have at the end, and hopefully we'll be able to answer any of the questions that arise. So the topics we're going to cover, firstly, the tilted balance as expressed in the 2019 NPPF and how this differs in its previous expression in the first NPPF of 2012. Secondly, the Monkhill case and the 15-point plan set out in that case by Mr. Justice Holgate for applying the tilted balance. Thirdly, a number of different aspects of the tilted balance test as expressed in the 2019 NPPF, which includes the meaning of relevant development plan policies, the most important policies for the determination of an application, when and how to determine whether policies are out of date, and then the standard of reasons that are necessary where a decision is made that the tilted balance does or does not apply. We'll then deal with some more specific matters regarding the tilted balance and 5-year housing land supply, and some practical pointers at the end when you're considering these provisions and how to apply them. So turning first to the actual text as found in the 2019 NPPF, and the new tilted balance can be found now at paragraph 11C and D. The tilted balance itself is in 11D, but C is also relevant to its application. So I'm going to deal with specific elements of the test in the slides that follow, but just to note from the text on this slide, paragraph 11C sets out the normal or the position or the starting point, which is the primacy of the development plan, where that plan is up to date. And then paragraph D sets out 3 triggers for the tilted balance. First, where there are no relevant development plan policies. Second, where the policies which are most important for determining the application are out of date. And third, a deeming provision in footnote 7, which says that policies are considered out of date in applications for the provision of housing in certain specified situations as set out in that footnote. Paragraph D is then followed by limbs 1 and 2, which set out certain circumstances in which the tilted balance, where it is triggered, is disapplied because either of those provisions apply. Then footnote 6 in limb 1 should also be noted, which sets out a list of policies which protect areas or assets of particular importance, which are capable of constituting a reason for disapplying the tilted balance. So what are the main differences between NPPF 2019 and NPPF 2012 in terms of the tilted balance? So the first one to note is that the presumption of sustainable development was previously described as a golden thread running through plan making and decision taking. This wording is no longer included in the NPPF, but it's clearly still a very significant part of the planning framework, as is evident from the number of cases we're going to go through which have discussed these provisions in the 2019 NPPF. As I've already mentioned, paragraph 11C emphasises the closer link between the tilted balance and the development plan. The development plan remains still very much the starting point for all planning decisions. And as we will see from the case law, just because the tilted balance applies doesn't mean the development plan has no role to play. A few more specific textual differences. With regard to the out-of-date policies trigger, in the NPPF 2012, this applied to all relevant policies, whereas the 2019 NPPF restricts this to the most important policies for the determination of the application. There's also slightly different treatment of the restrictive policies which protect particular assets or areas of importance which are capable of disapplying the tilted balance. So it's worth noting that these two elements, these two aspects which can disapply the tilted balance, are reversed in the 2019 NPPF. So the restrictive policies come first now, not the test which requires the harms to significantly and demonstrably outweigh the benefits. And this reversal, as Andrew will explain in relation to the case of Monkhill, is relevant. It's also necessary now to demonstrate that the restrictive policies provide a clear reason for refusal. So previously in the 2012 NPPF, the text said that policies must simply indicate that development should be restricted. And also the previous footnote 9, which set out restrictive policies, began with the words, for example, setting out an indicative list, whereas the current footnote 6 sets out an exclusive list of policies. So I mentioned that footnote 7 contains some deeming provisions which state that in certain circumstances, policies will be considered out of date in applications for the provision of housing. And those two situations are where the local planning authority cannot demonstrate a 5-year supply of deliverable housing sites, or where the housing delivery test indicates that delivery of housing was substantially below the housing requirement over the previous 3 years. So this is 75% unless transitional arrangements apply, as set out in Annex 1 to the 2019 NPPF. So it's important to note here that the word or, so that one of these two triggers is satisfied, then the tilted balance applies. And also the wording of footnote 7 is inclusive. So there can be other triggers for out of date, and it's possible for the tilted balance to be triggered in applications for residential development, even where an LPA has a 5-year housing land supply and satisfies the housing delivery test. So the paragraph 11 is followed by paragraph 12 to 14, which are also relevant for the tilted balance. Paragraph 12, again, along with paragraph 11C, notes the primacy of the development plan and it refers implicitly to the statutory presumption in section 38(6) of the Planning and Compulsory Purchase Act 2004, again reminding local planning authorities to determine applications in line with the development plan where there is an up-to-date development plan. And it also emphasises that neighbourhood plans form part of the development plan and that the statutory presumption applies to those plans too. Paragraph 13, again, recognises that the application of the tilted balance can have implications for neighbourhood planning and that neighbourhood plans should support the delivery of strategic policies in local plans. So essentially the emphasis here is on local plans and neighbourhood plans being closely aligned to avoid the situation where the tilted balance is engaged in relation to one of the plans, but the other is still in date. Paragraph 14 then deals with the situation where the local plan results in the tilted balance being engaged, and the test in 11D Lim 2 applies, but the neighbourhood plan is still up to date. So paragraph 14 says that where 4 requirements are satisfied, namely the neighbourhood plan is up to 2 years old, it contains policies and allocations to meet its identified housing requirement, the local authority has at least a 3-year supply of deliverable housing sites, and the local planning authority's housing delivery was at least 45% of its requirement under the housing delivery test over the previous 3 years. So where those 4 requirements are satisfied and there is conflict with the neighbourhood plan, then paragraph 14 provides that the adverse impact of allowing development that conflicts with the neighbourhood plan is likely to significantly and demonstrably outweigh the benefits. So limb 2 is likely to result in the tilted balance being disapplied. However, it's important to note that this word likely is included here. So it's still very much a matter of planning judgment. And it's not automatic that limb 2 will apply where those 4 requirements are satisfied. It's also important to note, as I've put on that slide, that the courts have indicated that the 2019 NPPF should be interpreted on its own terms and not by reference to the previous NPPF or to case law. Now, the courts are still continuing to refer to case law which was decided under the 2012 NPPF, and there's a large body of case law which will obviously continue to be relevant, but they're likely to dismiss overly legalistic arguments which seek to draw something from the differences between the 2019 NPPF and the 2012 NPPF in order to make a particular argument on the tilted balance. So now I'm going to pass back to Andrew for some more discussion on various aspects of paragraph 11D and the Monkhill case. Sorry, Andrew, you're still muted.
Thank you. Now just to screen share with the slides. So, yes, as Esther says, the approach that the courts have taken is to suggest that paragraph 11 in the new NPPF, 29 NPPF, should be read and interpreted in its own right, and that authorities and arguments relating to the old NPPF, in particular what was the equivalent paragraph 14 in the old NPPF, were no longer so relevant. And of course that's right. And one of the great things about the NPPF and about the cases concerning the NPPF is that a very great deal can be learned simply by reading the document in detail. And most of the cases that follow actually result from reading the document and understanding what its words mean and not trying to add words which are not there. And we'll see that coming through quite a lot. Now, one of the earliest examples really of this process of reading the document in order to understand what it really means came through in a couple of matters which are still relevant to paragraph 11 and the 2019 NPPF, which were determined under the old NPPF. And the first of those is the issue of what is there to the presumption in favour of sustainable development apart from paragraph 11. Now, for some years, I used to cross-examine witnesses. If I was acting for a local council, I would cross-examine witnesses and invite them to identify something other than paragraph 14, which gave effect to the presumption in favour of sustainable development. And they were never able to do so simply because there wasn't anything which gave effect to the presumption in favour of sustainable development apart from the words of paragraph 14. And out of that basic principle, there arose a dispute as to whether or not there were other requirements that had to be satisfied in terms of establishing that a development was sustainable other than compliance with paragraph 14. And two different lines of thought arose in the authorities. The Wychavon case suggested that even if one complied with paragraph 14, something more would be needed to determine that a development was sustainable and therefore ought to get permission. By contrast, the approach in Renew Land, which was always the approach which I thought was right, just simply based on the reading of the document, said that no, if you pass paragraph 14, if you complied with the tilted balance where that was engaged, then by definition, because of the wording of paragraph 14, because of the fact that the NPPF said this is how you do decision making, that was sufficient. Now that judicial uncertainty about the point eventually reached the Court of Appeal in the East Staffordshire case, and it was made absolutely plain that there was no presumption, there was no force, no bite to the presumption outside of what was provided for by paragraph 14. Obviously, paragraph 14, by setting up the tilted balance, is a pretty strong and important influence on whether or not planning permission is granted. But there was nothing beyond that presumption outside paragraph 14, and there were no further requirements beyond paragraph 14. So I used to say that paragraph 14 was the only game in town when it comes to the presumption, and I'm sure that is also correct for paragraph 11. So that old issue of trying to look for something more, or to try and say that even if something passed paragraph 14, it shouldn't get planning permission because it wasn't sustainable, that's all gone, and the fact that that's all gone will continue to carry over, I'm certain, into interpretations of paragraph 11. The second issue, and this is one that Esther's going to touch on with some more recent case law about the 2019 issue, but it's worth just mentioning it in the context of the 2012 NPPF, is this thorny issue of whether or not policies in a development plan are out of date simply because the plan itself is time expired, i.e. a development plan that was meant to run from 2005 to 2015. The fact that that date of 2015 is now passed, does that mean that by definition the policies are out of date? Now that caused a lot of litigation, and that was, or it appeared to be, finally settled in one of the many Gladman cases, this one Gladman and Daventry in 2016, settled by the Court of Appeal on the basis that just because a policy was in a time expired plan did not make it out of date. And the way one had to do it was to test the consistency with the NPPF. However, before the new NPPF came along, the waters were slightly muddied, or more than slightly muddied, by what appears to have been a throwaway comment by Lord Carnmouth in his Hopkins Holmes judgment, when he seemed to resurrect by simply saying, oh, well, if something's, obviously if it's time expired, it's out of date. And that rather resurrected this line of argument. Now Esther's going to tell us in due course about the cases which speak to that now, but we will note from the outset that this is something which has rumbled on through consideration of the old NPPF and may continue to rumble on into the interpretations of the 2019 NPPF. So there we are. That's the first thrust of argument that carries over from the old NPPF. The next thing to consider is, what does the first limb, paragraph 11D1, what does that actually mean, and how have things changed from the old approach in the old NPPF? Now this is quite a subtle and rather fun line of argument, and it's a line of argument I have some fondness for, as I was quite involved in developing it through inquiries and through the courts. Under the old NPPF, permission could be refused if policies for protection of particular things suggested that development should be restricted. And the list in footnote 9 of the old NPPF provided examples, for example, of the type of policies which suggested that development could be restricted, such things as heritage assets, green belts, habitat regs sites, and the like. And importantly, one of the examples was heritage coasts. a fairly narrow subject area, but nevertheless heritage coasts were specifically referred to, and as given as one of the examples. Now, the language that was in the NPPF referring to heritage coasts was remarkably weak. It's the old NPPF used to say that the decision makers had to have regard to the character of the undeveloped coast, particularly coasts which were heritage coasts. That's all that was said. And the argument then went, well, look, if the list is just a list of examples, which it is, and this language with respect to heritage coasts is sufficient to trigger the possibility of permission being refused under this limb of paragraph 14 as it was, the second limb of paragraph 14 as it was, that must mean that other policies in the NPPF, which are not included in the list of examples, but which have more restrictive language than the heritage coast language, that they also could trigger this. And it was a great sort of line of last defense for a local planning authority trying to resist the scheme. And matters went through the court and reached the High Court Coulson J in the Forest of Dean case, for which you've got the reference on the slide. And it was suggested that it is appropriate to give the word restricted a relatively wide meaning to cover any situation where the NPPF indicates a policy that cuts across the underlying presumption in favour of development. And so, of course, in seeking to resist development, given the very strong pro-development slant of the tilted balance generally, that second limb gave you something of a last line of defence against the grant of permission. And it was very useful, and I used it a lot, and it was successful a lot. Well, unfortunately, it was probably too successful for its own good, because it's been killed effectively by the 2019 NPPF. And two significant changes, well, three significant changes, I suppose, which end the argument which was capable of being advanced previously. First of all, the list of examples in paragraph 11, in the footnote 6 to paragraph 11, is now an exclusive list. So it is limited to such matters as heritage assets, green belts, heritage coasts, and so forth. And it is an exclusive list. So there's no opportunity now for sneaking in other parts of policy and saying that they can be included in the way one could previously. Secondly, the suggestion that a wide meaning can be given has been, again, rather torpedoed by the requirement now that clear reasons must exist for a refusal of permission to be justified using these categories which are exclusively listed. And so just by way of comparison, this is quite an important comparison in showing why the 2019 NPPF is more pro-development and has significant changes in that regard from the 2012 NPPF, and this last line of defence, as I've termed it, doesn't really exist anymore. So that's some hangovers from the old NPPF. We now turn to look at the first decision about the 2019 NPPF, and we do so in the context that, as Esther's pointed out, that Duncan Ousley in the appeal case suggested that one shouldn't be looking too much at old decisions. So this is a kind of almost a fresh sheet of paper, and it really arises from a sensible, clear and obvious reading of the 2019 NPPF. Quite a neat little case in some ways. The situation was effectively there were four packages of land being offered for redevelopment, relatively small scale redevelopment in fact. They were near Hazelmere in Surrey, and they were within an AONB. And it was the inspector's conclusion that one of the four packages of development had an adverse effect on the AONB. Now, the argument that was put forward was that the language which applies to protect AONBs did not mandate that permission be refused, or it did not even suggest that permission be refused unless exceptional circumstances prevailed. What the language says, it's paragraph 172 of the new NPPF, suggests that great weight should be given to conserving and enhancing landscape and scenic beauty in national parks, the Broads and AONBs. Nothing more, simply that great weight should be given to that factor. And it was suggested by the developers who lost the appeal, it was suggested by them that because that didn't mandate a refusal of permission, it simply says, well, great weight ought to be given, that therefore it wasn't enough to satisfy the requirements of 11D1, paragraph 11D1, that the application of policies in this framework that protect areas or assets of particular importance, that's the closed list of which AONB is one, provides a clear reason for refusing the development proposal. Now, on the facts of the case and on the principles of that particular argument, that was rejected out of hand. The judge simply said, well, that would neuter the protection that's given to AONBs, and the fact that it says great weight should be given to protecting AONBs et al. Is such as to enable it, of course, to provide a clear freestanding reason. That's not really a surprising conclusion, I wouldn't suggest. But what's more important about this judgment is that at paragraph 39 of the judgment, the court, Mr. Justice Holgate, set out a very comprehensive and logical framework for how one actually applies the tilted balance in paragraph 11. And I'm just going to work through those. They've been summarised on the slide, but you'll notice from the fact that the glasses have gone on that I'm going to just make direct reference to the judgment in front of me as well. Now, the first point, the first of the 15-point plan, as it's nattily been described, is that the presumption in favour of sustainable development does not displace section 38.6, i.e. the requirement that one decides in accordance with the development plan unless material considerations indicate otherwise. Now, this has always been a slightly difficult area of the jurisprudence of the presumption in favour of sustainable development, because in reality, I'm not really sure it's applied in practice. The way in which the NPPF works, of course, is that the NPPF is central government policy. It's a material consideration only. But it is patently, it seems to me, a material consideration which is capable of outweighing the statutory presumption in favour of the development plan, i.e. you may be suggested by the development plan to refuse, but elements in the framework suggest you should grant permission, and in those circumstances permission invariably or usually follows. And so although the development plan is, and the primacy of the development plan is recognised in statute, in the framework, and in the first point of this judgment, it isn't necessarily really the case, and a lot of attention does focus on how one applies the development plan. Secondly, 11C, if the proposal accords with an up-to-date development plan, will grant permission without delay. Well, fair enough, fairly obvious. And then where it doesn't accord, the flip side of that, planning permission should be refused unless material considerations indicate otherwise. Again, a restatement of the norm presumption in 38.6, but again, heavily modified in my suggestion by the way in which the framework actually operates and what the framework says. Now, moving on then to the way in which it impacts on the tilted balance. Where there are no relevant development plan policies, you grant planning permission unless Lim 1 or Lim 2 applies. And it's important to note immediately the wording is unless Lim 1 or Lim 2 applies. As we'll see, there's no doubt at all now, and there used to be some under the 2012 NPPF, there's no doubt at all that if either of the limbs which suggest permission can be refused, either of them are made out, then permission ought to be refused. Similarly, where the most important relevant development plan policies are out of date, and Esther's going to update us on each of these concepts, you grant planning permission unless Lim 1 or Lim 2 applies. Effectively then, number 6, if either Lim 1 or Lim 2 applies, then the presumption in favour of sustainable development no longer applies. This goes back to the central idea that paragraph 11 is the only game in town. It doesn't directly refer to the Renew Land and the East Staffordshire judgment, but that is effectively the working out of that principle. So if either 1 or 2 applies, Lim 1 or 2 applies, that's the end of the presumption in terms of that case. And of course, all of those issues, and particularly whether the limbs apply, are essentially a matter of planning judgment, which of course means they become very difficult to challenge in court, because we all know the very well-known principle that the court won't interfere with exercises of planning judgment. Where more than one policy in footnote 6, so this is our list, our exclusive list of policies which are sufficient or may be sufficient on their own to justify refusal if they provide a clear reason, where more than one of those is in play. So for example, if your site's in an AONB and also has a heritage asset which is affected, they can provide a clear reason for refusal in combination. So that combination of more than one policy can provide you with a making out of Lim 1, even if one of those policies and footnote 6 on their own would not justify a refusal. So you look at the combination, the effective combination of the footnote 6 policies. The 8 and 9 again goes back to this principle that it's either or. If either Lim 1 or Lim 2 are made out, then the presumption is not applied, you refuse planning permission. So generally speaking, the way to do it then is to look at Lim number 1, i.e. are there any clear reasons arising out of policies in that exclusive list in footnote 6? If there are, that's it. You refuse permission, end of. You don't even get to the tilted balance. And even if the tilted balance, had it been able to apply, might have suggested a grant of permission, if Lim 1 is made out, that's an end of it, and the second limb becomes irrelevant. And then the way in which Lim 1 works in detail is that the application of the restrictive policy must provide a clear reason for refusal. So it's not a question of simply saying, aha, this is a heritage asset, therefore there are footnote 6 policies in play, that's enough for refusal. You've actually got to work through the footnote 6 policy. So for example, with a heritage asset to which there is non-substantial harm, that policy, as you'll recall, allows for a public interest test. You've got to work through that public interest test and see whether the effect of it is to say that the proposal fails the public interest test. In that case, the less than substantial harm of itself is enough to justify a refusal of planning permission. In that case, that's your clear reason. That's Lim 1 applied. End of story. Paragraph 2, the tilted balance doesn't arise. It's not a free-for-all, point number 11, it's not a free-for-all in terms of taking account of things. You just have to look at the relevant footnote 6 policy, consider those matters which are drawn to your attention by that policy, apply them, come to a conclusion, and that then tells you whether you have a clear reason for refusal. Now, in some cases, for example, the green belt, you've pretty much got to do a full balancing exercise. And you do that as if the tilted balance doesn't apply. So, for example, green belt is the obvious example. as you know, you refuse permission for inappropriate development in the Greenbelt unless very special circumstances apply. The consideration of very special circumstances obviously includes pretty much everything that's there in the pot. And so you consider all of those factors. You've done effectively a full balancing exercise. But when doing that balancing exercise, you have not applied, you do not give that extra weight that the tilted balance calls for. You simply do the Greenbelt VSC equation. Again, if that suggests that permission ought to be refused, then limb 1 is satisfied, limb 2 doesn't arise, and permission is refused without further ado. However, where you're looking at heritage provisions, if you get to a situation where the test does not suggest permission should be refused for those heritage reasons, then limb 2 can come into effect. However, finally, number 15, and this is really the conclusion of this very helpful, thorough, but frankly utterly logical and drawn simply by reading the document. This is the end of this consideration for Mr. Justice Holgate. In most cases, there won't be a footnote 6 policy in play. Often not in an AONB, there isn't a listed building around the corner, and therefore there's no footnote 6 policies engaged. If you are in a circumstance then when the relevant development plan policies don't exist, or the most important policies are out of date, if any of those considerations apply, so that the whole of paragraph 11 is engaged, there's no footnote 6 policy, you skip over limb 1 because there's nothing to apply it to, you go straight to limb 2 and you apply the tilted balance. So that's the framework, the new framework, but as I say, pretty logical, pretty much derived from a straight reading of the document. We're now going to move on with Esther to explore some of the concepts that arise and which have been considered in the case law thus far. Esther.
Thank you, Andrew. So I've noted there's a question from John Boyd regarding the application of the tilted balance in the case of employment, applications for employment provision. And hopefully I can answer this in what follows, because I'm going to talk about some of the triggers for the tilted balance. So in the case of applications which don't involve the provision of housing, footnote 7 will not apply. So the tests in footnote 7 don't apply, but the tilted balance will still be triggered where either there are no relevant development plan policies or the most important policies for determining the application are out of date. So in an employment application, the policies you would be looking at would be whether there were any relevant employment policies in the development plan, or whether those employment policies were out of date. So what does relevant mean in the context of no relevant development plan policies? And this was discussed in the case of Paul Newman Homes, which we've already mentioned this afternoon, which was a challenge to an inspector's refusal of planning permission in a case where the local planning authority had failed to determine an application for 50 homes and associated development in the countryside. And the court upheld the inspector's decision to refuse planning permission. And the effect of the decision in this case is that there will be quite a high bar for establishing that there are no relevant development plan policies, because it is relevant, simply means relevant to determining the application, and relevant policies do not have to be important or decisive policies in the determination of the application. They just have to have some real role in that determination and not a fanciful or tangential connection. So essentially they are going to be policies which are a material consideration for the determination of the application. And the court also found that it's enough for simply one relevant development plan policy to be present in the development plan for this trigger not to be engaged. I've also referred to the case of Gladman there, which was decided on the NPPF 2012, but is still relevant to the definition of relevant, as in that case it was held that relevant policies could include a corpus or a group of policies which set out a spatial vision even where one of the policies, in this case for the supply of housing, was out of date, the fact that there remained a group of policies which could be applied, which set out where housing should go in the relevant local area, meant that there were relevant development plan policies, and the development plan could not be considered to be silent. So once you've considered whether there are any relevant development plan policies, you then need to go on to consider what are the most important policies. And the case of Wavendon gives more guidance on how to determine which are the most important. This was another application for housing development for 200 odd dwellings, and it was refused by the planning committee of the local authority, contrary to their officer's recommendation. Following the close of the inquiry, the Secretary of State recovered the appeal for his own determination and found, contrary to the inspector, that a 5-year housing land supply could be demonstrated, and refused planning permission on that basis. Ultimately, the court quashed the Secretary of State's decision because he had failed to give reasons for this difference on 5-year housing land supply. But the case also gives us some quite important guidance on how to work out which are the most important policies when considering whether those policies are out of date as a trigger for the tilted balance. So the court said that there wasn't a rule or a tick box instruction when you were considering whether which were the most important policies and whether these were out of date. And it's not necessary to demonstrate that all of the most important policies are up to date before you can disapply this trigger. So the court also explained that there needed to be a holistic approach, essentially a 3-stage approach. You first establish a basket of which policies are the most important. Then once you've got your basket, you consider which policies in that basket are out of date. And once you've identified which are out of date and which aren't, you consider, is the basket as a whole out of date? And this test and this language has been affirmed by a number of courts in subsequent cases. Paul Newman Holmes also gave further guidance on most important policies. And in that case, it was held that the word policies also includes the singular as well as the plural. So it's enough for the one most important policy in the case. If that is out of date, then the tilted balance applies. So having determined what are the most important policies, you then need to consider, as part of the 3-stage approach, whether they are out of date. And the case of Peel Investments, which follows on from Gladman and Hopkins Holmes, as Andrew has already indicated, discusses how to determine whether policies are out of date. This was a case involving 2 refusals of planning permission for residential development and associated works by Salford City Council. Again, these were recovered by the Secretary of State for his own determination, who upheld the local planning authority's refusal. And the court ultimately upheld that decision of the Secretary of State. The relevant policies for the determination of this application were contained in a development plan, which was stated to expire in 2016. And part of the arguments made before the court by Peel Investments were that those policies were time expired and so should be considered automatically out of date as a matter of law. The judge, Mr. Justice Dove, disagreed with this, and applying Gladman, held that just because the policies were time expired did not mean that they were automatically out of date. It was relevant that they were in a time expired plan, but this wasn't a matter which was dispositive of the issue. He then went on to state that when you're considering whether policies are out of date, you need to first consider consistency with the NPPF, applying paragraph 213 of the NPPF, which explains that where you have policies which were which came into force before the NPPF, then the weight to be given to them must be assessed in terms of their consistency with the NPPF. And you also have to consider whether the policy is still relevant and capable of achieving its objectives, applying it to the facts on the ground. So, and this is always going to be a matter of planning judgment for the decision maker, but it does actually have to be considered by the decision maker and grappled with. If the policies are in a time expired plan, then the decision maker will need to consider whether they're out of date and how much weight they should be given. So one of the most recent decisions on the tilted balance, this was judgment was handed down in March of this year, is another Gladman case. And this case considered the relevance of the development plan. And Andrew and I have already explained the emphasis that's in the NPPF 2019 on the primacy of the development plan. And this decision really supports that emphasis and just reminds all involved in the planning process that the development plan does continue to apply, notwithstanding the tilted balance might be engaged. So this was a challenge to two inspectors' decisions where Lim 2 of paragraph 11D applied because the local planning authority could not demonstrate a 5-year housing land supply. And the question was whether, when considering whether the harms significantly and demonstrably outweighed the benefits, it was necessary to, or it was possible for the inspectors to consider development plan policies as well as the policies in the framework. And you'll see from the quote I've put on the slide from Lim 2, I've paraphrased, Lim 2 specifically refers to policies in the framework. So the claimant's argument was that the inspectors could only consider the policies in the framework when applying Lim 2 and not the development plan. And the court found that where the tilted balance applies, you still need to consider and give weight to the development plan policies. Now this was what's called a rolled up hearing, where the court was considering whether to grant permission to apply for judicial review as well as considering the substantive issues. And they actually found that on this ground and on all other grounds, permission should not be granted. And they found that this position, that the development plan needed to be taken into account under Lim 2, was actually clear from preceding case law and clear from the statutory and policy schemes. So they gave pretty short shrift to this argument. And they also identified a number of situations in which the development plan would be relevant when applying Lim 2 and would need to be taken into account and given some weight. For example, where the development plan, where the proposal accords with the development plan as a whole and or the most important policies for determining the application, but for some reason those policies are assessed as being out of date, you will still need to consider that accordance and give some weight to the development plan or to those most important policies. Or there might be a situation where a local planning authority cannot demonstrate a 5-year housing land supply, but does not satisfy the housing delivery test, but because of some short-term issue, but the development plan is actually very recently adopted or up to date in all other respects. So in that situation, you'll want to consider, or a decision maker will need to consider whether and how much weight to give to those development plan policies which are up to date, although the deeming provisions apply under footnote 7. So it's for the decision maker to consider how much weight to give, but they do actually have to engage with the issue, and it cannot be argued that the development plan has no relevance. So that deals with the triggers for the tilted balance. In the recent case law, there's also been some explanation of the standard of reasons that are necessary in tilted balance cases. So Wavendon properties I've already mentioned in the context of most important policies. Actually, the main point on which this case, on which the decision of the Secretary of State was overturned in this case, was on the question of reasons. And the principles on reasons really affirm the sort of well-established position in planning cases that it's only necessary to give reasons for the main or principal controversial issues. So in cases where a particular trigger for the tilted balance is not relied on by a claimant, for example, the most important policies being out of date, there's no need for a decision maker to give reasons for that on that particular point. The adequacy of reasons in these cases, as in all cases, will always be a fact-sensitive question in each case. But in this case, the particular situation where the Secretary of State differed from the parties and the inspector who heard the inquiry on whether there was a 5-year housing land supply, that is the kind of situation in which reasons will need to be given. Another case dealing with the standard of reasons is Green Lane Chertsey. This was a challenge to a refusal of planning permission by an inspector for a housing development at Green Lane in Chertsey in Surrey. It wasn't disputed that the local planning authority could not demonstrate a 5-year housing land supply. And the court agreed with the claimant and quashed the inspector's decision on the basis that the inspector had failed to apply the tilted balance or have regard to the substantial need for new dwellings in the area. And the failure to apply the tilted balance was really because it wasn't evident from the reasons that the tilted balance had been applied. So on reasons, the court found that it is possible to apply the tilted balance without explicitly referring to it. And in fact, in this case, the tilted balance wasn't referred to by the parties during the inquiry or relied on by the claimant as a reason for granting planning permission. So arguably, it was open to the inspector not to mention the point in his decision. But actually on the facts, when you're applying the tilted balance, if there isn't a 5-year housing land supply, as an inspector, you need to explain how the tilted balance is disapplied, i.e. does limb 1 or limb 2 apply? And the inspector didn't do this in the case. Green Lane Chertsey also deals with tilted balance and weighing up material considerations in that tilted balance. And again, it affirms well-known planning principles. The tilted balance is different to the normal planning balance. So you really need to show that material considerations are strong enough to overcome the tilt or presumption which arises as a result of limb 2. It's not sufficient just to find harm or material harm or that the development is out of keeping in the area. That kind of language indicates that the normal planning balance is being applied, but you need something more in order to significantly and demonstrably outweigh the benefits. And it needs to be really clear in the reasoning of the planning decision maker that a different planning balance exercise has been undertaken when they're applying the tilted balance. So that's a quick run through some of the really recent cases on the issue. I'm now going to pass back to Andrew for a further discussion of the case law and some practical pointers.
Thank you, Esther. Yes, and now back to my slides. So just 1 second. Thank you. Now, I'm going to deal first with Hopkins Homes. This, of course, is the Supreme Court case, which triggered much discussion. In some ways, it's become rather dated by the effects of sorry, hold on, I have a suspicion that you're not seeing my slides. Just give me 1 moment, please. Good, sorry about that. Now, Hopkins Homes, yes, become possibly rather dated by the new provisions of paragraph 11, but it does, of course, still have some fundamentally important learning for us as the only, I think, Supreme Court case specifically on the tilted balance and so forth. The key point about Hopkins Homes, and it's relevant for all future considerations, is that the absence of a 5-year supply, exactly as the document says, is of itself enough to trigger the tilted balance. And so the extensive sort of legalistic arguments about which specific policies are out of date, whether it was a narrow or a wide interpretation, if you remember those tortured debates, is not really relevant anymore. And of course, with the Wavenden approach of seeking to identify a basket of cases, a basket of the most important policies, that therefore requires even less attention on trying to nail down a specific individual policy and say that one's out of date. The point is there a basket of policies which is out of date? So the key thing still to take away from Hopkins Holmes really is the issue that it's the absence of a 5-year supply alone which is enough to trigger the tilted balance, as provided for by footnote 7, and it's really important just to focus on that fact. However, just to deal finally with Hopkins Holmes, one point that does emerge, John Boyd asked a question about the application of the tilted balance to employment policies, and in fact in Hopkins Holmes there is an explicit reference to the fact that events subsequent to the adoption of a plan may render employment policies out of date. So for example, the example given there was the moving into the area of a new employer with a massive new factory. That might render the whole factual background in terms of employment policies out of date just by virtue of the facts on the ground. And so Hopkins Holmes is a very useful citation if one's seeking to make that sort of argument. But the key thing about Hopkins Holmes is the 5-year supply. Now the question then arises, and it was also again just touched on in the Gladman case, which Esther's been just dealing with, is what's the role of out-of-date policies? Policies which are out of date do not disappear in a puff of smoke and cease to have any existence. There's a series of cases of which Crane is perhaps the most useful, and although they're decided under the old NPPF, are certainly still relevant, as we've seen through Gladman in the new NPPF. There's a range of cases which set out why and the circumstances in which relevant development plan policies may be relevant. Out-of-date development plan policies may be relevant. And the most important thing is, particularly in the context of housing, is really how far away are you from being at a 5-year supply? If you're really close to having a 5-year supply, but you just don't quite make it, few units short, then the policies, although they are put into the tilted balance, so the tilted balance is still there, but the development plan policies can still carry a lot of weight. Or, for example, if there's a new development that's coming along, a big new strategic scheme, which means that you will have your 5-year supply relatively quickly, even if at the point the appeal is being considered or the application is being considered, there isn't a 5-year supply. Again, in those circumstances, the development plan policies relating to housing and spatial distribution and so forth can still be given significant weight. Obviously, if you're miles away from having a 5-year supply and there's no real likelihood of anything coming along to change that position for a while, then the housing policies will carry limited weight. But it's very important to remember that there is a necessary exercise in assessing whether or not and the weight to which should be given to policies which are out of date, particularly if they're deemed to be out of date by virtue of the operation of footnote 7, because there's no 5-year supply. And so what this does mean, that it's absolutely critical, obviously, to establish the 5-year housing land supply position. It's changing now, thankfully, but you will not believe the number of reports to committee, in particular draft reports to committee I used to read, where planning officers simply hadn't assessed the situation of the 5-year housing land supply. It is literally the first question that you really need to ask in a substantial consideration of a housing application. But it is important that one needs to look at the broad magnitude of the shortfall. There's always been a tendency, I think, from local planning authorities, once they know they haven't got a 5-year supply, they just say, oh, whatever, we haven't got the time and the resources to try and challenge what a developer's saying. But it really matters, because if you're close, if you can get the inspector to accept that you're close to having a 5-year supply, then you may well find that your housing policies and your other policies, which are otherwise deemed to be out of date, can still carry substantial weight in an appeal. So it is really necessary to put the effort into establishing what the housing land supply position is. Just as almost really a footnote for the detail of that exercise, the Chiltern and Bayberg case set out you don't need to go so far into the minutiae that you look at draft AMRs and so forth and take account of different positions therein. And the final point on the 5-year housing land supply for the tilted balance, it's a purely quantitative exercise. That simple issue of whether or not the balance is tilted, whether that's triggered, is a purely quantitative exercise. Now, of course, qualitative arguments, type of housing, what the position is more generally, the position even within the distribution of housing within a local planning authority's area, all those qualitative issues can come in at the stage of working out what weight to give to out-of-date local plan policies. But the simple issue of whether or not the balance is triggered or not is a purely quantitative exercise. And so that really brings us to our final slide. The first thing to say is this is very much a watch this space area of planning. Lots of the High Court decisions, they're mostly all first instance decisions on the 29 NPPF, because there hasn't simply been time, particularly with COVID-19, for them to reach the Court of Appeal. And so a lot of them are under challenge. Peel and Monkhill are under challenge. I know Peel is going to the Court of Appeal next week. For local planning authorities, I mean, the advice we would give is look very carefully at the Monkhill framework. Tread carefully through it, follow it, and it is a very, very useful guide as to how to apply the balance and how to get it right. Take heart from the fact that the Wavenden decision, by saying that a basket of the most important policies has to be sort of weighed up and then considered as to whether or not it's in or out of date, is useful for local planning authorities, because the old game of developers of seeking to find somewhere, anywhere in the development plan, a plan that was a policy that was out of date, and therefore trying then to say that even on the basis of a relatively minor policy being out of date, that the tilted balance was in play. Well, that's all gone because of Wavenden, because one has to look for the basket of the most important policies. So that's a comfort for local planning authorities. For developers, there are nuances still, and in fact, of course, the tilted balance itself is still there as a huge big shove towards the grant of planning permissions. But there are changes. The end of the Forest of Dean approach, the need for a clear reason for refusal under Lim 1, you know, that's a help for developers in many ways. One is likely now, given what the Paul Newman case has said, one is likely to struggle to establish that there are no relevant development plan policies. But one should always remember that the category of out of date is explicitly not closed, not just a matter of the 5-year supply. And so one has the opportunity of challenging the basket of most important policies, but the grounds upon which one can challenge are never closed and always open to constructive and imaginative interpretation. And that's where developers can possibly think of coming to people like us for some help on that area. Anyway, those are some practical points. I will stop the slides now, and we'll look for questions. I know that before I started this last tranche, we dealt with the questions which had arose. And we see 2 now. Let's have a little look. Right, there's just one remaining question. Esther, I don't know if you've read this and have any immediate thoughts while I read it.
Yes, so my immediate thought is really, so that for those of you who haven't seen it, it's about whether there's a double trigger. So if both of the things in footnote 7 apply, so if there's both not a 5-year housing land supply and the housing delivery test hasn't been complied with, then whether that has an impact on the tilted balance, so it kind of tilts it more in favour of granting planning permission. I mean, this is always going to be a matter for the planning judgment of the decision maker, and it's for them to, while they have to obviously grant planning permission unless the benefits significantly and demonstrably outweigh, it's for them to determine the level of that significance.
Well, I think I would observe that the term double trigger is probably a slightly misleading term in the sense of how it impacts on the application of the tilted balance. I mean, there are 2 possible triggers for housing policies being deemed to be out of date by footnote 7. That's your double trigger, I think. If you are in a situation then you are where that one or both of those triggers is triggered, you are then looking at all of the factors in the tilted planning balance. It goes back to the approach in Crane, which I spoke of a few moments ago, in the sense that if you have not only a lack of a 5-year supply, but your housing delivery test has gone south in a big way, then both of those would be factors which would tend to suggest that your out of date, your deemed to be out of date housing policies should be given very limited weight. If you have failed one but met the other, then it might be said that, well, those out of date, those deemed to be out of date housing policies should be given considerable weight, even within the framework of the tilted balance. So it's very much a question of separating out in your mind the issue of, first of all, is the tilted balance engaged at all the factors we've talked about, no relevant policies, out of date, etc. Footnote 7. Question. So issue 1, is it engaged at all? And then secondly, what factors and what weight are you putting into the balance when you actually come to apply the tilted balance on the assumption it's triggered? So that's I think our answer to the first question, and we've had kind words from John Boyd on his. So that's kind. Thank you, John. I'm glad we were able to help. And unless in the next 2 seconds another question pops up, I will thank you all very much indeed for your attendance. Thank you, Esther, for your contribution. We hope that's been helpful, and we look forward to seeing you all again at the next FTB planning webinar. Thank you all very much. Good afternoon.